In my hand, I am holding a motion that I drafted to the court in Michael Irvin's $100 million defamation lawsuit, asking that the court publicly disclose the defendant Jane Doe's true name to the media and to the public. More on that later. Many of you have left comments expressing confusion or frustration over why Irvin's complaint still refers to his accuser as Jane Doe instead of using her real name. In this video, we'll look at the law addressing anonymous John and Jane Doe parties in a lawsuit. Then I'll explain why I believe Irvin has not disclosed Jane Doe's identity to the public up to this point, and when we can expect to actually learn her real name. Before I get started, a quick disclaimer: this video is not legal advice. So with that out of the way, let's get into the video. Let's start by taking a look at Arizona Rule of Civil Procedure 10, which describes the content that a plaintiff like Michael Irvin must include in his complaint. So here we have Arizona Rule of Civil Procedure 10. If you look at subsection A, it addresses the names of the parties, and it says that every pleading must have a caption in the form prescribed by Rule 5.2. And it states that the title of the complaint must name all the parties. And then if we look down here in subsection D, it actually states that using a fictitious name to identify a defendant. If the name of the defendant is unknown to the plaintiff, the defendant may be designated in the pleadings or proceeding by any name. So that would be like John or Jane Doe. If the defendant's true name is discovered, the pleading or proceeding should be amended accordingly to add that true name. And so right here, I made a note that Irvin has presumably learned the true identity of Jane Doe because the court in Texas ordered Marriott to produce over all of the written witness statements and the statement from the accuser, Jane Doe, that she wrote out after the incident. And so that would obviously contain her true name. And we know for a fact that Irvin's lawyer has already received those documents. So they know Jane Doe's real name at this point. At least under this rule, they are required to file an amended complaint that replaces the Jane Doe with the defendant accuser's real name. This raises in my mind several interesting questions though. Why do courts generally require public disclosure of a defendant's true name in a lawsuit? Have courts recognized any exceptions to this rule? And if so, do any of those exceptions apply to Michael Irvin's case to protect Jane Doe's identity? Why would Irvin go out of his way to protect his accuser's identity? That is probably something a lot of you are asking. And then finally, will we ever eventually learn Jane Doe's true name? I'm going to answer each of those questions in this video. The first question I'll address is, why do courts generally require public disclosure of a defendant's true name in a lawsuit? The first reason is the public's right to access judicial proceedings. The people of Arizona and the United States at large have a right to know who is using their courts and for what purpose. Such transparency discourages perjury, it discourages bias, it gives the public assurance that the proceedings are fair and allows the public to supervise and scrutinize the proceedings. In practice, courts apply a balancing test to decide whether to let a party appear in a case under a pseudonym like Jane Doe. They generally balance Jane Doe's interest in keeping her identity a secret against the public's interest in knowing her true name. Courts often grant anonymity when, number one, identifying a party's true name creates a legitimate risk of physical or mental harm, or number two, when anonymity is necessary to preserve privacy in a matter of sensitive and highly personal nature. Courts, however, have generally refused to grant anonymity to a party when they are wanting to remain anonymous in a lawsuit simply to avoid embarrassment, unwanted attention, or economic harm. In Irvin's case, the factors that weigh in favor of disclosing Jane Doe's real name to the public include the high level of public interest in this case and the fact that Irvin is a public figure who has been very publicly accused of alleged misconduct. And number three, the other three hotel employees are identified by name in Irvin's most recent complaint, the one he filed in Arizona. And at least to my knowledge, none of them have suffered any kind of harassment or harm as a result of being named in Irvin's complaint. Factors that weigh against disclosing Jane Doe's true identity, her real name, to the public include, number one, the fact that Irvin himself chose to protect Jane Doe's identity when he named her as Jane Doe in his refiled complaint, even though he knew her real name. Number two, identifying Jane Doe's real name may expose her to the risk of physical or mental harm in the form of assault, bullying, whether that's in person or cyberbullying, threats, intimidation, or harassment. And number three, requiring the disclosure of Jane Doe's real name will expose her at the very least to intense public scrutiny and ridicule, which may discourage others from reporting legitimate cases of harassment and assault in the future. Marriott did allege in one of its earlier court filings in Texas that the Renaissance Hotel in Phoenix has received a number of threatening phone calls after Irvin created what it claims to be a media frenzy surrounding the surveillance tape and the incident in general. The second reason why the Arizona Rule 10 and the federal rules of procedure require that a plaintiff like Irvin actually disclose the defendant's true name is a more practical one. It's to ensure that the person named as a defendant in a lawsuit actually knows that they're being sued. So here we have Arizona Rule of Civil Procedure 4, which deals with the contents required in a summons. Specifically, subsection B1 states that a summons must name the actual parties to the lawsuit. And then subsection C down here, 4C, deals with fictitiously named parties like John and Jane Doe defendants. It says, if a pleading identifies a party by a fictitious name under Rule 10D, the summons may issue and be directed to a person with the fictitious name. Here we saw that Irvin issued the summons to Jane Doe defendant. The return of service of process on a person identified by a fictitious name must state the true name of the person who was served. So Irvin's return of service for Jane Doe must actually replace Jane Doe with her true name in order to comply with this rule, Rule 4C. Now let's take a look at the docket sheet in Michael Irvin's lawsuit and see if we have a return of service that has been filed showing service of Jane Doe with her real name in it. So here we have the docket sheet in Michael Irvin's case. A docket sheet is basically a chronological list of everything that has been filed in a given case. And this is the docket sheet in state court of Arizona for Michael Irvin's case. You can see Michael Irvin's name right there listed as the lone plaintiff. And if you look down here, a summons has been issued to each of the defendants, and a affidavit of service has been filed for each of the defendant as well, except for the Jane Doe defendant. The only affidavit of service that we're missing is the one that would include Jane Doe's real name. It has not been filed in this case yet. So that could mean one of two things: that Jane Doe has not been served yet, which is unlikely since it looks like they were able to serve all of the other defendants fairly quickly, basically on the same day that the summons issued, or that Jane Doe has been served, but Michael Irvin did not file it with the court. If I had to guess, I would guess that Irvin has already served Jane Doe with a copy of the summons and complaint, just as he has with the other defendants in this lawsuit, but his lawyer has deliberately chosen not to file the summons with the court and publicly reveal Jane Doe's name. Instead of filing the return of service that would reveal Jane Doe's real name, Irvin's lawyer may have made a deal with Jane Doe's lawyer that Irvin won't publicly file the return of service disclosing Jane Doe's real name if Doe agrees not to challenge service or the court's jurisdiction over her. So at this point, you might be wondering, why would Michael Irvin go out of his way to protect the identity of his accuser, who has very publicly accused him of wrongdoing and led to his cancellation from the NFL Network and indefinite suspension from TV? Here is my take on what is going on here. Michael Irvin currently has the moral high ground, which is key to winning his case. Marriott and the other defendants ceded the moral high ground to Irvin when they did several things. Number one, when they refused to interview Irvin's two eyewitnesses during its investigation. Number two, reporting to the NFL Network that Irvin harassed the female staff member, resulting in Irvin's indefinite suspension, despite what we all saw on the surveillance footage. Number three, evicting Irvin from its hotel prematurely. And then number four, refusing to produce a copy of the surveillance video to Irvin, even after the court ordered it to do so, as though it had something to hide. If Irvin discloses Jane Doe's name to the public, he will undoubtedly expose her to public contempt and ridicule online and possibly even at work. This might lead people to be more sympathetic towards Jane Doe and more likely to view her as some type of victim in this case. At this stage of the case, I don't see a true advantage strategically for Irvin to publicly disclose Jane Doe's name. By voluntarily protecting Jane Doe's identity for now, on the other hand, Irvin appears selfless and noble, almost like a martyr who is protecting the very person who has publicly allegedly defamed him and destroyed his career. So the final question you might be wondering is, will we ever actually learn Jane Doe's true identity? And if so, when? Well, there are three scenarios in which we may learn Jane Doe's true identity. First, Irvin may in fact publicly file the return of service if it turns out that he just hasn't been able to find and serve her yet. Under Rule 10C, the return of service would have to provide Jane Doe's true name, as we discussed earlier. This could happen any day now, depending on if and when Jane Doe was served with the summons. Second, Irvin may at any point on his own volition file an amended complaint that actually uses her real name instead of Jane Doe. By now, Irvin clearly knows the true identity of Jane Doe. Therefore, under Arizona Rule of Civil Procedure 10, he must file an amended complaint with the court that contains her real name. Finally, if the case goes to trial, the trial will certainly be held in open court where anyone from the public or press may attend. Irvin's lawyer will unquestionably call the defendant, Jane Doe, to the witness stand where she will be sworn in to tell the truth and then asked to tell her side of the story to the jury. So at the very latest, we would likely learn Jane Doe's true identity if this case goes to trial, at trial, whenever that may be. So if you watch this video to the very end, let me know in the comment section whether I should actually file this motion to disclose the name of the Jane Doe defendant to the public or not. And of course, as always, thank you for watching.